Okay. Alvin Lawrence, is that you?
Yes, sir.
25 CR 852?
Judge, he's electing to set his case for trial.
Who is the person who is the victim here? Girlfriend?
Ex-girlfriend.
Okay. Have y'all talked to her at all? Has the state talked to the
Yes, sir.
victim lately?
Yes, sir.
Okay. Because I've done this long enough. I know what's.
She's not cooperating, so I'm going to prove this up without her.
Okay, okay. I find out you've communicated with the victim. I'll do what we did yesterday, put you in jail like we did the other person. The rules are you do not communicate, nor anyone on your behalf communicate with the victim. I know what goes on a lot of times. People don't follow the rules. That's why they're in this court for the most part. But one of the rules they really abuse is trying to get with the victims to change their stories, which would be inappropriate.
So that the court is aware. I've known about the victims not wanting to cooperate. He's got
Let me know if you can prove something, and we'll bring him up here and we'll deal with it so that your head would spin.
I want to cover the offer on the record if I could, Judge.
Court does not tolerate
Specific.
the rules not being followed. You cannot try to intimidate or change the victim asked for this, and then later on, people try to make them feel guilty, which is backwards. And it is a criminal offense for you to try to influence this person in any way. And I just I would welcome the presentment of any proof and get him back here as soon as possible so we could deal with that, like we dealt with the man that's in prison now for what he did the other day, trying to influence the victim, his girlfriend, in that trial.
This man is not eligible for probation from a jury as a felony conviction. I've offered him probation in an attempt to try to resolve it. If when we get to trial, that will not be offered. He will only be looking at either winning or going to prison.
And we have had conversations about that, Judge. He's aware of that.
Okay, well then the deal's off.
Yes, sir.
He had a chance. He's had his chance. Be quiet. I'm speaking. Thank you, sir. You had your chance, and we're going to go to trial, and the victim cases have been proven without a victim being present, and it gets out during the trial what's happening and why the victim is not present, and the jury's understands. And they have a history of making certain kinds of decisions. They don't find that amusing at all. So it's deals off. There's no deal. Set it for trial. It will be set for trial. And that is that. Next is Alvin Lawrence. What about you?
If I may make an oral request, he is on an ankle monitor. If I could request to have that taken off.
State objects.
Tia Ballard is next. Get her resetting for trial. You can have another one. Is that in? Yes. We have it's a bond hearing.
Sir, I filed a motion requesting bond.
Read 'em out, please. Thank you. 15-23549 is gonna look.
Good.
On the state on this, what are y'all doing on the cocaine allegation that was tested positive? Are y'all gonna do
I think
something?
they're still waiting on the lab on that one, Your Honor.
Yes, the new alleged.
We've got two cases. We've got two different dates of problems, don't we?
Yes, sir.
You're Calvin Lawrence, you're Calvin Lawrence. You're charged here in a motion to revoke probation that was filed on September 29th of this year. which alleges that you were on probation a long time too,
Yes, sir.
that you committed the offense of illegal possession of a controlled substance on or about June 18th, 2025. And you failed to immediately report to your probation office your arrest on that you were required to do as a condition of probation. And then finally, a urine sample of yours was tested on or about April 29th of 2025, which is 2 months before you are alleged to have committed the illegal possession of controlled substance. And on April 29th, your urine was tested at the probation office, I guess.
Yes, sir.
And it tested positive for cocaine, which is a violation of your probation. Let's see.
And alcohol as well, Your Honor, on that day.
And I didn't see that. Why only do one wrong thing when you can do two? What she kind of do is I looked at the probable cause affidavit on this June 18th, 25. Love it.
I didn't bring my books. That we must have been broke.
All right.
Yes, Your Honor. We are requesting a bond for Mr. Lewis. He is on deferred adjudicated probation. Essentially, he's been doing well for 9.5 years of the 10-year probation. He did express, he did relapse earlier this year, in which I believe he did express that to his probation officer prior to him taking the drug test, in which he made them aware that he would be positive and was seeking some help. Mr. Lewis, prior to these relapses, had done exceptionally well to complete everything that was required of him. He was actually running a halfway house, sober living home for several years, Your Honor, and actually ran or managed the cafe here at the courthouse downstairs for several years. Your Honor, we're just asking that while this motion is pending and while we're awaiting any results of this new alleged offense, that he be granted a bond along with any conditions that the court may deem necessary, such as a drug patch or things of that nature, while the motion is pending, so that we can hopefully get his case disposed of soon.
What's that say?
Yes.
And I believe he just also, what was that? On September 25th, Your Honor, he also tested positive for cocaine as well.
That's on July 24th as well.
Is that different from what's involved?
Yes. Ms. Taylor after that.
You're gonna add, or you're gonna add? that
Yes,
to it?
yes, Your Honor. Yes, sir.
Yes.
So we've got two other events.
I believe there was another offense, from July 24th, 2025, of possession of controlled substance.
Well, no, the judge can give us straight jury.
Anything else?
No, Your Honor.
Well, can we be ready for a motion hearing on this?
We could be ready on the other, we're still waiting on the labs on the possession of controlled substance, but we can be ready on the others pretty much anytime. Where he tested positive for alcohol, cocaine, and then they failed to report the new arrest.
3 weeks?
Yes, sir.
3 weeks? Let's have a hearing. You're not gonna wait long. I'm gonna rule on this.
Judges, he's not entitled to a bond based on the type of probation that he's on.
Is that right?
Deferred, I
Say that again?
believe he's on deferred adjudicated probation, I believe he is entitled to a bond.
Yeah, I know that. I thought you said he wasn't entitled to it.
Oh, no, that's it.
Yeah, $50,000
Okay.
plus drug patch. But this won't, we're gonna have a hearing in 3 weeks and it'll conclude all of this. One way or the other. Y'all can get the motion amended so that we give the defense all the information. Very disappointed. I thought we were gonna be successful on this. I'm very disappointed. This is you're looking at 20 years in prison. You understand?
Yes,
Thank
That's
you.
the orders.
Oh, no. Great, that's all. I'll get out.